what types of products and ideas are processed faster. So is there such a thing of that, Troy? Have you noticed that certain technologies?
Yeah, for sure. And, it often corresponds with, what's hot in the news that you see. For instance, right now, AI, artificial intelligence, which it kind of took over for blockchain. That used to be the hot technology. In the patent office, patent applications get assigned to examiners, based on the examiner's area of technology. So when you've got tons of applications being filed on AI-related applications, for instance, the number of examiners in that area doesn't necessarily increase. So you've got the same number of examiners that have a ton of applications to examine. So in very hot technologies, the applications tend to get processed slower, just because the examiners are overwhelmed and they have very large queues of applications. And unless you do something like a request for accelerated examination or some kind of petition to make special, then your application is just going to get examined in the order that it was received. So you go to the bottom of the pile or the top of the pile.
Right.
Yeah, but on the other hand, if you're filing an application in a relatively, an area of technology that just doesn't see so much inventive activity going on, then your application is going to get examined a lot faster.
Question for you, Troy. This kind of relates to what we see on the trademark side. So on the trademark side, if I have a client who's got some pending trademark applications at the USPTO, and say they've been around for 6-7 months pending at the USPTO waiting examination, and we submit a third application, a lot of times that third application is going to get reviewed with the first two. If it's in the same field, I assume that it's going to get assigned to the same examiner, and he or she might decide to just do all three at the same time.
Yep.
Do you ever see that on the patent side?
I don't see that so often. No.
Okay.
Now I've seen that in the trademark side also. But no, I have not seen that in the patent side. What will happen though, if you have a pending application and you file a continuation application of that, the continuation application is basically a new application, for anyone who doesn't know. It's basically the same application that you refile, but you're seeking different types of claim coverage. So you'll have initial application, you'll get one kind of claim set, and then you'll decide, my claims aren't really broad enough, or I want to cover a different aspect of my invention. So then you file what's called a continuation application, which is you have the same description, but you're changing your claims, and you get to go all the way back to your initial priority date. So for those kind of applications, often they will get assigned to the same examiner, and you will see examination happen more quickly. I'm not sure why. I can only assume because the examiner is already familiar with the application, and it's something they can get off their plate pretty quickly because they have that familiarity. I don't know if there's a formal process in the patent office where, that I don't know exactly how that happens. I've actually tried to find out because we've had situations where we actually want to get the application assigned to a different examiner.
Yeah, there's a couple of trademark examiners at the USPTO. When I see their name come up on an office action, I just knock my head against the floor,